The point of the arbitration program was that defense people wouldn't come to these arbitration hearings, and plaintiff would be put to this proof that they'd get an award, trial de novo would be requested, and all that occurred was exercised in futility. That hasn't occurred. I'm not so sure I know all the reasons why it hasn't, but at least it's a good thing that situation is not developed.
Alex, I want to finish with 1614B, which provides that the arbitrator may, but is not required to make a record of the proceedings. Any records of the proceedings are personal to the arbitrator, and his notes are not subject to discovery and shall not be given to anyone except pursuant to a criminal subpoena issued in a criminal investigation or prosecution for perjury.
You want to take up where that stops, Bill, and talk about deposition subpoenas and wrapping up that part of it?
Yeah. Again, Norm started this out by saying that 1613 was really the heart of the new arbitration law. And I agree with him because this is the area where you can find great savings in time and concomitantly savings in money for your client. And that goes for both the plaintiff and defense side. The rules of evidence apply in judicial arbitration. This is not like an uninsured motorist arbitration or something of that nature. The statute provides that the rules of evidence shall be applied except, and the exceptions are set forth in 1613B, 1, 2, and 3. Now they are separate and distinct sections, and you have to read them, you have to understand them, and if you do, and you use them properly, you can save yourself many days of trial. You can save your client many dollars. Norm has been talking about 1613B1 and 2 with reference to medical reports, medical records, those types of things. You must give notice to your other side as required in that section. It's under 1613B that you can get a police report in. And Norm has also pointed out to you that the arbitrator must not consider any opinion of ultimate fault expressed in a police report. That's true. I'd look very closely at the police report, and if I found something in there that was helpful to me, even if it was opinion, I would argue that it was not an opinion of ultimate fault, and therefore the arbitrator might consider it. I don't know whether the arbitrator will buy that or not, but I think that you've got an area to do some creative thinking if you want to. In some of the other areas, the purpose behind the giving of notice is a little different from the purpose of having to actually produce a witness. That may not be a little clear. Take a look at 1613B1 and 2. 1613B3 deals with the depositions. You don't have to provide the other side with a copy of the deposition, but you do have to give the other side notice of your intention to use the deposition. If you do that under 1613B3, you cure a lot of irregularities, and you're going to be able to introduce this deposition. Remember, under B1 and B2, you had to give notice and you had to provide copies of certain reports. Under B3, you don't have to provide a copy of the deposition. Well, what happens if you forget? And all too often that does happen. You forget that you're going to use such and such a document. In the case of a deposition, or for that matter in the case of other documents, if you don't fall within 1613B1, 2, or 3, the rules of evidence apply. If you can get it in under some other rule of evidence, then you're free to do so. Bear in mind that there are provisions under 1613B3 for preserving objections for deposition testimony. Probably the major objections are the ones that are under CCP 2016D. Take a look at B3, give notice that you're going to use the deposition, and I think you're going to be in good shape. You don't have to show that the witness is unavailable if you handle it this way. One of the things that you might do, and I know that a lot of attorneys do this already, so I may be preaching to the choir, But one of the things that you might do in view of the new law on depositions is when you take the deposition, get a stipulation from your opponent that you may retain the original deposition and that you will bring it to the hearing for the arbitrator's use, because otherwise the depo isn't going to be there. Another thing that you might consider is a stipulation that a copy of the deposition may be used with the same force and effect as if it were the original.
Bill, let me ask you, you're talking about depositions now, but what happens in a situation where defense has subpoenaed all the medical records and the plaintiff hasn't ordered copies, and you indicate in your notification to the plaintiff and to the arbitrator that you're going to submit all these medical records, and I, the plaintiff, say, well, I want copies of those. Do you think I'm entitled to copies from you?
You know, this is a question, Norm, that we've wrestled with in mock arbitrations that we've put on for the Bar Association, in a number of other instances. At some time, I thought it was a silly question until in one of those mock arbitrations, someone stood up from the audience and said, but an arbitrator just ruled against me the other day, wouldn't let me put in the medical records even though those were the ones that I had subpoenaed. This was a plaintiff's attorney who came up with that statement. The rule does require you to provide copies to the other side. Again, if you look at this very technically, I think you're stuck with that. However, of course, the rules do not say anything about who has to pay for the copies. So perhaps you offer to provide those copies to the other side, together with a bill for doing the additional photocopy. There's another alternative, and I think it's probably one that I would employ simply as a safeguard. Let's say that I'd subpoenaed a whole stack of Kaiser records and they were 4 or 5 inches thick. But actually, all I wanted out of them was the emergency room record for this particular accident and the 3 visits thereafter. I think what I'd do is I would photocopy those 3 or 4 pages, and I would provide those 3 or 4 pages to my opponent, probably at no cost. And if he wished to submit, or she wished to submit the additional Kaiser record, then I'd leave it up to them to do so.
I agree. That's a very difficult problem, but I believe the saving grace of trial de novo will overcome any parties trying to subvert the arbitration procedure in some similar fashion.
But I think the discussion has uncovered the big weakness in Rule 1613, and it certainly is, as you say, the heart of the guts of the whole program. But it was originally done with the thought that almost all these cases were going to be personal injury cases, and so it's cast in terms of that expectation, which may not be true with the new mix of business under the arbitration law that stood since July 1 of 1979. And I think, too, that it's inconsistent with the recitals of the legislation to encourage simplified procedures. And one might hope that in coming months the statute or the rules will be amended to permit more of these records to come in without the necessity of cross-examination or even the right of cross-examination in many instances, to reduce to the very minimum the subpoena of persons who prepared these writings or have given this written testimony. The subject is very actively being considered by the advisory committee on the mandatory arbitration rules, and it may well be that there'll be some rule changes in this area before there'll be changes in any other part of the rules.
Well, I certainly agree that we are trying to save money and trying to save time, but you have to be fair. And I think fairness is really important in all of this, because if it's not fair and somebody feels that they haven't gotten a fair shake, you're going to end up back in the courtroom with a long, drawn-out trial. And I must concur with Norm on the idea of a more formal rather than an informal hearing. I know that the concept perhaps was a relaxed hearing in somebody's office at 7 or 8 o'clock at night, but I think that a structured hearing where you're talking to Mr. So-and-so or Ms. So-and-so rather than Charlie, Jane, Jack, etc., does much more to aid in the final resolution of the matter. I think the litigants feel that they've had a fair shake and a reasonable hearing. I think if you approach it the other way, they look at it as being a backroom conference and they haven't had their day in court.
You know, Alex, you touched on something a while back, and that is the particular arbitration awards in connection with the trial awards. Wasn't there a study made in San Diego County in regard to that at one time?
Well, that's